The Supreme Court is expected any day now to publish a ruling overturning the landmark 1973 case of Roe v. Wade, which guaranteed federal protections for access to abortion procedures. While a decision has not yet been rendered by the Supreme Court, a leak of an opinion of the court drafted by Justice Alito in February 2022 cures a ruling in Roe, leaving many circles concerned as to what the future of abortion services in the United States may look like. On the opposite end of the spectrum, anti-abortion political action groups have already been preemptively celebrating their likely victory that was nearly 50 years in the making. Before we get started with today's video, be sure to drop a like and subscribe to the channel to keep up with all my latest content. Every like really helps out my channel and helps me continue to bring you top quality legal news. Remember to comment down below with your thoughts on the potential overturning of Roe v. Wade, and I'll be replying to as many of you as I can. Now, without any further delay, let's get right into it. In order to understand Justice Alito's drafted opinion, the issues at hand, and the likely outcome of an overturning of Roe v. Wade, it's necessary to take a look at the decision in Roe itself. In Roe, the Supreme Court held that the Constitution's due process clause found in the 14th Amendment provides a fundamental right to privacy that protects women's liberty to choose whether or not they have an abortion. The reasoning is made by inference, meaning that the Constitution does not explicitly state in any place that a person has a fundamental right to privacy. The Due Process Clause of the 14th Amendment provides that no state deprive any person of life, liberty, or property without due process of law. In Roe, the court explains that the Constitution does not explicitly mention any right of privacy. In a line of decisions, however, going back perhaps as far as Union Pacific Railroad Company versus Botsford, the court has recognized that a right of personal privacy or a guarantee of certain areas or zones of privacy does exist under the Constitution. Importantly, while the Roe court agrees that the right to privacy exists and is compelled by the argument that said right to privacy extends to a pregnant woman's decision to have an abortion, the court explains that a state may properly assert important interests in safeguarding health, in maintaining medical standards, and in protecting life. At some point in pregnancy, these respective interests become sufficiently compelling to sustain regulation of the factors that govern the abortion decision. The privacy right involved, therefore, cannot be said to be absolute. This is extremely important. Let's try and explain this in simple English. The court holds in Roe that pregnant women have a right to decide to have an abortion, inferred by the right to privacy, which is inferred from the 14th Amendment. The court clearly explains that this right is not absolute, and a state is within its bounds to restrict a woman's access to abortion services, at least at some point in pregnancy. Importantly, the court avoids the issue of when exactly some point is. Roe attempted to create this timeline by identifying a trimester standard, but this was later eliminated in the 1992 case of Planned Parenthood versus Casey. There are a couple significant legal issues within the Roe decision that has found us in the situation we are in today. Perhaps most obvious, the decision made in Roe generates a right to an abortion through inferring that said right from another alleged right that the court had already inferred. Confusing, isn't it? This inference of an inference has been repeatedly criticized by legal scholars as a detachment from the function and purpose of the 14th Amendment. Justice White wrote in his dissenting opinion in Roe that, quote, "I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant women and with scarcely any reason or authority for its action. Invests that right with sufficient substance to override most existing state abortion statutes." This position has been held since the decision in Roe by many and leads us into May's leaked decision. The undecided case of Dobbs versus Jackson Women's Health Organization revolves around a 2018 Mississippi law banning abortions after 15 weeks of pregnancy. An injunction has been issued by the courts against this law, preventing its enforcement pending the Supreme Court's decision on the theory provided in Planned Parenthood versus Casey, preventing the regulation of abortions before fetal viability, which is generally considered to be 24 weeks of pregnancy. In anticipation of the overturn of Roe, 20 states have already drafted legislation with intent to further restrict abortion access should Dobbs overturn Roe. The primary issue at hand in the Dobbs case revolves around the viability standard and its alleged inadequacies. Among other issues, The state has alleged in Dobbs that fetuses can experience pain after 10 to 12 weeks of gestation, concluding that the practice of abortion after this period is therefore an inhumane practice. One of the primary contentions against the right to abortion raised during oral arguments in Dobbs was presented by Mississippi solicitor Scott Stewart, who argued that the decision made in both Roe and Casey are now unworkable given new facts have come to light, in reference to continued scientific advancement and expanded knowledge on gestation and pregnancy. Jackson Women's Health Organization, on the other hand, contests that the arguments made by Mississippi are substantially similar to those made in Planned Parenthood versus Casey and have already been determined to be without merit. On May 2nd, 2022, a leak of Justice Alito's draft opinion in Dobbs was obtained and published by Politico. While that opinion is drafted and may not be determinative of the final outcome of the case, this extremely uncommon security breach has allowed us interesting insight into the function of the nation's highest court. The Supreme Court operates in secret, notoriously having always refused video recording during oral arguments, making this insight even more rare and interesting. In the opinion, Justice Alito writes a scathing review of Roe, calling it egregiously wrong from the start. Alito uses a variety of approaches to discredit the Roe decision, namely drawing on the premise that abortion has never been permissible in American society prior to the Roe decision. Alito argues that the intent of the right to privacy, while he believes it is already weakly inferred, cannot be construed to apply to abortion, given the fact that leading up to Roe, abortion was commonly considered impermissible in the United States. This argument may have merit, but it's interesting to see that it's raised 50 years after the original decision in Roe. Given the approximately 250 years of United States history, abortion has been permissible and protected for nearly 20% of that time. While during the drafting of the Roe opinion, it may be that abortion had no historical or cultural protections. It seems reasonable to say that that decision and the 50 years of concurrent case law following the decision has therefore, in a way, integrated the right to an abortion into the American history and traditions. Perhaps not. Alito does make a compelling point in writing that Roe and Casey have failed to settle the abortion issue, instead only inflaming debate and deepening division. Indeed, the court has repeatedly ruled that states are permitted to regulate abortion services within the context of the viability standard, leaving the question before the court whether all pre-viability prohibitions on abortion are impermissible. It remains inconclusive whether the Alito opinion represents the decision to be made in Roe, but is rather unlikely that a complete reversal of the decision outlined in Alito's opinion is in store either. The Washington Post has recently reported that Chief Justice Roberts is drafting a different majority opinion which will permit the Mississippi law while not overturning Roe v. Wade. The decision is expected to be released by the court in late June or early July, and we'll definitely be here to cover it. Thanks for watching. That's going to be it for now. Remember to like, comment, and subscribe to our channel, and where we are constantly posting new content, check out my other social profiles in the description below to make sure you always stay up to date. We are constantly producing new and exclusive legal content for each of our platforms. I'll see you all next time.